Thank you all for being here and braving the elements. We don't take for granted that you made it. I love events like this that bring together truly our entire community. Looking around, students, if you're a student, raise your hand. Thank you guys. We have a number of faculty colleagues. Can you raise your hands? Great. We have alumni and other friends. Welcome. It's great to have you. This is truly a signature event for us. I should say my name is Michael Waterstone. I have the honor of being the dean of our law school. And it's with my great pleasure that I welcome you to the 2025 Melville B. Nimmer Memorial Lecture with Jane Ginsburg. So for those of you who are joining us by the electronic feed, wherever you are, thank you for tuning in. And for everybody else, truly, thank you for making the extra effort and being here. Before we continue, I want to acknowledge that UCLA law sits on the traditional, ancestral, and unceded territory of the Gabrielina Tonka peoples. As members of a land-grant institution, we at UCLA pay our respects to the ancestors, elders, and relatives, past, present, and emerging. So this lecture is one of our great annual traditions. It's actually only the second one that I've attended. For more than 30 years, leading legal scholars have been delivering this lecture in celebration and in honor of one of our legends, Mel Nimmer. Mel was the preeminent copyright scholar of his day, a titan in the field, and a professor here at UCLA Law from 1962 until his death in 1985. Mel is widely credited for making UCLA Law one of the leading schools in intellectual property. The success of our current Ziffer Institute for Media, Entertainment, Technology, and Sports Law, which is hosting tonight's lecture. Thank you, Cindy and Zimmer and Ziffer colleagues. And consistently ranks as a leading entertainment law program, really rests on the foundation that Mel built. His impact continues to resonate. His success in the 1971 Supreme Court case of Cohen versus California remains a landmark in free speech and First Amendment law. And everyone knows his signature work, Nimmer on Copyright. When generations of students and lawyers, to those who learned from Mel, to my classmates, to all of you, think about copyright law, to this day they think Nimmer. I want to thank the Nimmer family for continuing this special tradition. Notably, Mel's son, David, has been a longtime lecturer at UCLA Law, and as I've had the opportunity to work with him on some various issues, really just a pillar of the not just UCLA Law, but UCLA community. I also want to thank other family members of the Nimmer Lecture Committee for their work in making this really signature event possible. So our speaker today is Jane Ginsburg, a renowned authority on intellectual property law and a staunch defender of authors' rights. She is the Morton L. Janklow Professor of Literary and Artistic Property Law at Columbia Law School and the Faculty Director of Columbia's Kernochin Center for Law, Media, and the Arts. Many of her friends and colleagues are joining us today, and they know Jane is one of the most prolific professors in intellectual property. She has written key case books in a number of areas of IP law, legal methods, and statutory methods. She was also a co-reporter for the American Law Institute's Principles of the Law, Intellectual Property, Principles Governing Jurisdiction, Choice of Law, and Judgments in Transnational Disputes. And truly, generations of law students and IP scholars and practitioners have learned and benefited from her knowledge and vision. Her lecture is entitled Humanist Copyright, and we look forward to hearing her perspective on issues at the cutting edge of copyright law today. So we are truly honored that you are here to deliver this year's Nimmer lecture. Please join me in welcoming Jane Ginsburg. At some point tonight, the voice of Jane Ginsburg may be played by our colleagues Ian Tang, but we'll let that unfold.
Right. Sorry. Thank you very much, Dean Morrison. As you can hear, many things are conspiring against this lecture. The weather, the flooded classrooms, and the fact that I lost my voice yesterday. And therefore, seeing is not a digital replica. She will be, if necessary, speaking my words, but not in my voice, currently non-existent voice. So, and I think we're going to proceed as follows. I will give the lecture until my voice gives out, or you can't stand hearing this sort of feathery locution. I assure you that my natural speaking voice is a little more in the alto range. But at some point, we may switch, and seeing will continue. I hope that we will have time for questions and answers, at which point I will come back if I haven't left the podium by that point, so that we can have a discussion. But we'll see how things go. And again, I thank you for your indulgence. So, much American copyright rhetoric vaunts technological progress and economic incentives. One reading of the Constitutional Copyright Clause characterizes copyright as a necessary, if unappealing, encouragement to the advancement of innovation. These emphases tend to obscure the centrality of human creativity to copyright law and theory. In this lecture, I develop a counter-narrative. I seek to highlight the role of human authorship in the copyright scheme. The title, Humanist Copyright, references not only current debates over AI-generated outputs, but also the proposition that authors' rights embody and advance human achievement. Copyright celebrates human creativity for multiple reasons, economic and social, but also grounded in the person of the author. I trace these concepts to Italian Renaissance humanism and the emergence of the author as entrepreneur. My exploration of the role of authorship proceeds in three parts: historical, doctrinal, and predictive. First, I will review the development of author-focused property rights in the pre-copyright regimes of printing privileges and in early Anglo-American copyright law through the 1909 Copyright Act. Second, I will analyze the extent to which the present U.S. copyright law does and does not honor human authorship. Finally, I will consider the potential responses of copyright law to claims of proprietary rights in AI-generated outputs. I will explain why the humanist orientation of U.S. copyright law validates the position of the Copyright Office and the courts that the output of an AI system will not be a work of authorship unless human participation determinatively caused the creation of the output. The phrase humanist copyright nods to Italian Renaissance philosophers such as Pico della Mirandola, whose 1485 oration on the dignity of man emphasized human autonomy in a human-centered universe. While Pico extolled self-determination in shaping individual lives, the kindred between the authorship of one's being and the authorship of works of art and literature is apparent. Concepts of creative autonomy took root and flowered in 16th century Italy, as Giorgio Vasari's Lives of the Artists attests. My counter-account of copyright thus begins in 16th century Rome and focuses on one protagonist in the development of of authorial rights. The typical account of the pre-copyright world of printing privileges, particularly in Venice, France, and England, portrays a system primarily designed to promote investment in the material and labor of producing and disseminating books. In this version of the story, protecting or rewarding authorship was, at most, an ancillary objective. More recent scholarship, however, reveals that with respect to documents found in the Vatican's secret archives, the majority of 16th century papal privileges were awarded to authors. The predominance of authors suggests that their personal creativity afforded a ground for bestowing exclusive rights. Let us consider one of these authors, the Florentine artist Antonio Tempesta. In the late 1580s, painter and printmaker Antonio Tempesta perceived new opportunities in the burgeoning print market. Printed images of Rome proved increasingly popular with pilgrims, effectively tourists, particularly in anticipation of the Jubilee of 1600. The newly mastered engineering feat of transporting obelisks symbolized the passage of grandeur from Roman emperors to popes. Obelisks displaced from their pagan settings now rose throughout the city, facing churches and ecclesiastical palaces. An immense bird's-eye view depiction of the city, greater in size and detail than any predecessor, would celebrate the new Rome and would advertise Tempesta's representational accomplishments. Tempesta anticipated great success for his map. Accordingly, he sought to ensure that he would retain the profits and control the number of copies made. Thus, he obtained a privilege granting him a 10-year monopoly on printing or selling his map. Tempesta was by no means the first map maker or printmaker of Roman images to seek exclusive rights from the Pope and other sovereigns, but Tempesta's papal privilege stands out for the arguments he made to support his application for the grant. The 1593 petition you see here evokes justifications spanning the full range of modern intellectual property rhetoric, from fear of unscrupulous competitors to author-centric rationales. Invocations of labor and investment and unfair competition-based justifications were familiar, indeed ubiquitous, in Tempesta's time, and they still echo today. Other petitions also made explicit the incentive rationale that underlies investment protection arguments. They contended, as did Tempesta, that the grant of a privilege would encourage future productivity to even greater public benefit. We can see that long before the 1710 Statute of Anne, the event which is commonly accepted as the birth of the modern era of copyright, the precursor regime of printing privileges understood exclusive rights as incentives to intellectual and financial investment. The pre-copyright system had thus already firmly established one of the philosophical pillars of modern copyright law. Tempesta's petition, however, went further than its antecedents with respect to the second pillar of modern copyright law, that is, the justification based on the natural rights of the author, a rationale that roots exclusive authorial rights in personal creativity. Tempesta's contention that new works routinely receive privileges was not novel, but he focused on the rights of the creator and equated creativity with his personal honor. modern moral rights conception of copyright. Moreover, Tempesta urged that his entire future production should automatically enjoy a 10-year monopoly on reproduction and distribution in the Papal States, subject, he acknowledged, to papal censors. In more modern terms, Tempesta was seeking a result equivalent to, "I created it, it's mine." Tempesta also tied his request to incentive rationales. A broad grant of rights would spur him ever more eagerly to greater creativity for the benefit of all. And this conflation of creativity-based and labor incentive conceptions anticipates the frequent oscillation and overlap in modern copyright between natural rights and social contract theories of copyright. The 1710 Statute of Anne became the first law systematically to vest copyright in creators. Its title states its purpose to be for the encouragement of learning, a goal echoed in its first paragraph, which exhorts the encouragement of learned men to compose and write useful books. Parliament acknowledged that the damage done to authors and their families by unauthorized copying of their books threatened that objective. Vesting in authors an exclusive right of publication to last for 14 years, with an additional 14 years contingent on the author's survival, would promote that purpose. The Statute of Anne shifted the law's emphasis toward authorship, both by making authors the first owners of copyright and by conditioning the duration of exclusive rights on the life of the author. Moreover, Parliament responded to authors' demands to provide an ongoing financial interest in their works by decreeing that at the end of the initial 14-year term, the sole right of printing or disposing of copies shall return to the authors thereof, if they are then living, for another term of 14 years. The second 14 years enable the author to grant rights anew from a stronger bargaining position. The statute thus broke new ground when it not only gave the author the rights at the outset, but also, providing she survived, returned them to her for a second time. The Statute of Anne and the copyright laws adopted in the former colonies set the stage for the Copyright and Patent Clause of the Constitution and for the enactment by the first Congress in 1790 of the first federal statutes governing copyrights and patents. After the close of the Revolution, 12 of the 13 former colonies passed laws to afford a measure of protection to authors, pursuant to a recommendation of the Continental Congress, and to the entreaties of Noah Webster, who tirelessly and self-interestedly urged that protecting authors not only responded to the claims of natural justice, but would spawn the creation of the kinds of American-oriented school books, geographies, and dictionaries essential to the development of the citizenry of the new republic. Webster thus coupled the cultural policy of the new nation with the recognition of authors' inherent rights in their works. Similarly, many state enactments, such as this preamble to the 1783 Massachusetts Act, mingled natural rights rhetoric with utilitarian rationales. At the federal level, the United States followed England as the only nation at the time to design exclusive rights around the author. The Constitutional Copyright Clause instructs Congress that exclusive rights were to go to the authors of writings. The clause's further direction that the exclusive right be for limited times in the plural may also advert to the Statute of Anne's conditional second term of copyright, and thereby implicitly endorse the author's reversion right established by the English example. The Constitutional Copyright Clause melds utilitarian and authorial property rationales. The goal of the property right is to enhance public knowledge, but the rights, though limited in time, are secured, not granted by Congress. Selection of the term secured may have meant that the framers understood copyright to have been a natural right pre-existing at common law, as Madison suggested in Federalist 43. The Constitution's Copyright Clause thus, at least in part, supports an author-centric view of U.S. copyright. Moreover, as perhaps forecast in the Constitution, the nation's first Copyright Act of 1790 adopted the Statute of Anne's two-tiered duration scheme with a second term of 14 years contingent on the author's survival and a reversion of rights to the author. 19th and early 20th century U.S. courts perceived the reversion right consistently with the labor deserts and fairness rationales advanced from the outset of Anglo-American copyright. Thus, a circuit court in 1846 declared, "It was the genius which conceived and the toil which compiled the book that is to be rewarded by even the first copyright term, and no one ever dreamed that an assignee could alone take out the second or extended term unless he is paid for it, clearly contracted for it." The last part of the court's solicitude for authorships introduces an ominous qualification. Authors enjoy reversion rights unless they clearly contract them away to the initial assignee. Given authors' weaker bargaining position, it is no surprise that publishers form contracts systematically provided for the alienation of the first and the renewal term, without any separate consideration for the latter. The assignability of the renewal term would seem to undermine its purpose of affording authors improved opportunities for remuneration, but the Supreme Court in a 1943 controversy involving the song when, oops, how do I go back? Okay. When Irish Eyes Are Smiling, ultimately ruled that the author's first term assignment of the second term bound him to convey the renewal term to the original publisher. Its first implementation of its power to enact copyright laws, Congress conditioned the availability of exclusive rights on compliance with burdensome formalities, including publishing a record of the work's publication in one or more newspapers for 4 weeks. One might view a formalities-freighted copyright regime as fundamentally antithetical to an author's rights concept of copyright. Rather than securing a natural entitlement, copyright would merely be a conditional government grant. In this social contractarian view, copyright is a quid pro quo, and it is the author's burden to assert her rights properly. Formalities thus make free copying the default position. So characterized, formalities clash with a characterization of copyright as springing from the creative act. Such tidy coherence may be theoretically satisfying, but it is also substantially anachronistic. In historical context, the opposition of natural rights and state monopoly concepts was much less sharp. In the case of the Statute of Anne, the act focused on the rights of authors authorship, but the statute also adopted the regulatory framework established under the 1662 Licensing Act, including registration with the Stationers' Company and deposit of copies of books with designated libraries. Arguably, Parliament retained the bureaucratic aspects of pre-copyright printing privileges because the prior system was known and had worked. In the case of early U.S. enactments, many of the pre-constitutional state copyright statutes referenced earlier included preambles with ringing declarations of natural property rights, but then copied the Statute of Anne almost verbatim, including its requirements of registration and deposit of copies. Indeed, in the U.S., authorities throughout the 19th century conveyed highly mixed messages regarding the nature of copyright and the role of formalities. While some courts articulated a rigidly positivistic concept of copyright, to which strict adherence to formalities formed a cornerstone, treatise writers, this is not, okay. Treatise writers eloquently insisted on the natural rights of authorship, generally treating formalities as an administrative afterthought, a means of perfecting title, rather than of divestiture. Similarly, the 1831 Copyright Amendments made registration of the work before its publication an unambiguous prerequisite to the obtaining of federal copyright protection, but the Judiciary Committee report accompanying the bill extolled the author's natural entitlement to a property right. Nonetheless, formalities and the highly restricted view of copyright they ultimately symbolized came to dominate the U.S. copyright landscape, particularly following the Supreme Court's 1834 decision in Wheaton versus Peters. One might venture different explanations for the centrality of formalities to Wheaton v. Peters' delimitation of U.S. copyright. The standard modern account asserts the framers and their successors' suspicion of restraints on competition. In this view, Congress and the courts were far more fearful of monopoly than desirous of fostering authorship. An alternative account suggests that the Wheaton court's embrace of a highly positivistic, formality-defined approach to copyright was a necessary corollary of the court's federalism jurisprudence. Henry Wheaton's assertion of a residual, formality-free state common law copyright clashed with the court's rejection 10 years earlier in Gibbons versus Ogden of residual state common law patent rights, whose assertion undermined federal control of interstate commerce. Formality-bound federal copyright was thus a legacy of the Marshall Court's determination to eliminate barriers to interstate trade and to consolidate federal power. Nonetheless, one need not view Wheaton versus Peters as a perennial rejection of author-centric bases for U.S. copyright. On the eve of the 1909 Act, Justice Oliver Wendell Holmes, Jr. offered one of the most enduring and quoted pronouncements of author-oriented copyright. Note here that the default position in Holmes's view is copyrightability. Because the author created the work necessarily expresses the author's personality. That expression is copyrightable unless Congress says otherwise. Holmes has turned Wheaton versus Peters positivism on its head. Rather than searching for an affirmative grant of protection, in that case for low commercial art, a circus poster, Holmes presumes the coverage of creativity and shifts the burden to show that Congress has specifically denied protection. Act, federal copyright protection commenced upon publication of the work in compliance with formalities. Non-compliance would cast the work into the public domain. Federal copyright thus arose neither from the act of creating a work nor from disseminating it, but rather from distributing copies in the prescribed way to inform the public that the author claimed exclusive rights in her work. By defaulting to the public domain, the pre-76 Act system in some ways kept authors on the periphery. The 1976 Act, by contrast, reorients copyright by declaring that copyright subsists in original works of authorship fixed in any tangible medium of expression. Unlike the 1909 Act, which referred to the object of protection as the copyrighted work, the 1976 Act founds protection in original authorship. Moreover, as soon as the author commits her work to a tangible medium, such as on paper or in computer memory, copyright arises in the work, and the work remains protected regardless of compliance with formalities. The 1976 Act, therefore, makes creativity the linchpin of coverage. The text's adoption of the term subsists critically underscores a shift from prior Copyright Act's utilitarian exchange toward the natural rights principle of you created, it's yours. With the important exception of works made for hire, the 1976 Act vests copyright in the creators of an original work of authorship. The creator thus starts out with rights that she may transfer by contract. Section 204A provides a copyright statute of frauds. Thus, grants of exclusive licenses, like those of assignments, must be manifested in a signed writing to be effective. Equally significant, the 1976 Act clearly provides that the author's rights are divisible. The combination of divisibility and the requirement of a signed writing may justify a presumption that when the author assigns something less than all her rights, the scope of a grant made on or after the effective date of the 76 Act should be interpreted narrowly. For example, the grant of the exclusive right to perform a work through one medium of communication, such as broadcasting, would not extend to other media, such as webcasting. The author may, of course, authorize exploitation in multiple media, but if the contract does not explicitly cover the exploitation at issue, the proposed presumption would exclude it from the scope of the transfer. But even with the presumption of strict construction of the scope of a grant, it is possible for a U.S. author, for good and valuable consideration, expressly to assign all right, title, and interest in and to the work in all media, now known or later developed, for the full term of copyright, including any renewals and extensions thereof, for the full territory which shall be the universe. And I am not making this up, as copyright lawyers in the audience surely know. A contract of this kind presents no ambiguity as to the scope of the grant, and therefore no room for presumption of strict interpretation. Worse, with one exception, this is a valid contract. The exception is not the extraterrestrial aspect. It seems that authors can validly grant rights for Mars after we plant the American flag there. Rather, the exception concerns the author's inalienable right to terminate grants of U.S. rights 35 years after the grant's execution for works other than works made for hire. Thus, even if the contract purports to grant rights in perpetuity and for a lump sum, the author can nonetheless retrieve most of her U.S. rights 35 years later. I feel like a 15-year-old boy who's Thank you for bearing with me. Maybe by the end I'll have some semblance of the real voice. The 1976 Act termination right is the successor to authors' reversion rights modeled on the Statute of Anne. Congress narrowed the scope of the reversion and made it contingent on the author's timely exercise. But importantly, it also corrected the 1909 Act case law that upheld authors' advance alienation of their renewal term rights. The statute now provides that termination of the grant may be effected notwithstanding any agreement to the contrary. Thus, a grant of U.S. rights is in perpetuity only if the author fails to terminate it. Any assertion that the 1976 Act has moved authors' rights from the periphery toward the center of U.S. copyright must contend with at least two significant statutory shortcomings. First, apart from the exceedingly limited Visual Artists' Rights Act, the 1976 Copyright Act does not confer a right to be recognized as the author of one's works. Second, the Works Made for Hire doctrine not only divests employee authors and certain freelance creators of copyright ownership, it also deems the employer or commissioning party the statutory author, adding insult to injury. Of all the many counterintuitive features of U.S. copyright law, the lack of an attribution right may present the most significant gap between perceived justice and reality, and the greatest counter-argument to my contention that copyright is a law of authors' rights. Most national copyright laws guarantee the right of attribution, yet, perhaps to the surprise of many, no such general right exists in U.S. copyright law, nor in other U.S. laws. The Works Made for Hire doctrine, carried over from the 1909 Act, denies copyright ownership to employees for works created within the scope of employment, as well as to creators of certain specially ordered or commissioned works, provided the parties to the commission comply with certain formal requirements. Worse, the 1976 Act denominates the employer or hiring party, rather than the work's creator, the statutory author. The persistence of the Works Made for Hire doctrine seems to undermine my contention that the 1976 Act evolves U.S. copyright law toward a law of authors' rights. Nonetheless, the 1976 Act considerably cabins the doctrine relative to prior law. Compared to the potentially innumerable commissioned works that would qualify as works made for hire under the 1909 Act's instance and expense test, the 1976 Act limits the commissioned works capable of characterization as works for hire to a closed list of 9 enumerated categories. The 1976 Act substituted a unitary term for the prior renewal scheme and exempted works made for hire from the author's termination right. What need then to denominate employers as authors rather than as indefeasible first owners? Perhaps Congress instituted this labeling sleight of hand to inform to the constitutional empowerment of Congress to secure exclusive rights to authors. As long as Congress calls a non-creator an author, perhaps there is no constitutional quibble with the beneficiary of the initial vesting of rights. The proposition that an author is anyone or anything, such as a juridical person, whom Congress chooses to call it, heralds arguments that AI outputs lacking human authorship may be protectable under the 1976 Act, a proposition to which we now turn. The advent of literary, musical, and artistic outputs of generative artificial intelligence tests the role of human authorship in the U.S. copyright system. Not for the first time, as earlier case law addressing machine-assisted creation demonstrates. The Supreme Court broadly construed the constitutional term authors and writings in Burrow-Giles versus Cerrone, decided in 1884. The court confronted a constitutional challenge to Congress's 1865 inclusion of photographs in the Copyright Act. The defendant had argued that the photographic process was a purely mechanical one, requiring no authorship, and that a photograph was not a writing. The court, however, held that an author is anyone to whom anything owes its origin, and that a writing is any production of an author that includes all forms of writing, printing, engraving, etching, etc., by which the ideas in the mind of the author are given visible expression. The court noted that the photograph at issue, which I think many of you recognize, a posed portrait of Oscar Wilde, exhibited harmonious, characteristic, and graceful placement of its subject, and rather than being a purely mechanical reproduction, was an original work of art, the product of plaintiff's intellectual invention, of which plaintiff is the author. Napoleon Cerrone's carefully contrived image dripped art with a capital A, and amply met the constitutional standard for the writing of an author. From Cerrone, we learned that intellectual invention characterizes authorship, and that machines may participate in giving visible expression to the author's conceptions. But what of outputs in whose production human intervention is more attenuated? These may result from random processes, whether machine assistance or natural forces. For example, in Kelly versus Chicago Park District, the Seventh Circuit ruled that an installation of wildflowers in Chicago's Grant Park lacked sufficient authorship because the patterns of wildflowers primarily resulted from natural forces. The Compendium of U.S. Copyright Office Practices states that the office will not register works that lack human authorship. In particular, the compendium specifies that the office will not register works produced by nature, animals, or plants, and the office will not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author. Similarly, the Court of Appeals for the Ninth Circuit held that a crested macaque, remember Naruto, could not sue under the Copyright Act for the alleged infringement of photographs that the monkey supposedly had taken of himself, or herself, it's not clear, for all animals, since they are not human, lack statutory standing under the Act. In the realm of AI art, the Copyright Office has required something more than trivial authorial control. In particular, when analyzing an application to register a work that incorporates more than a de minimis amount of AI-generated content, the Copyright Office will endeavor to assess whether the traditional elements of authorship in the work were actually conceived and executed not by man, but by a machine. The office has thus far rejected the registration of AI-generated pictorial works 4 times. The first rejection concerned an image that the applicant alleged was the wholly autonomous output of a machine. The asserted absence of human participation made it an easy case for the Copyright Office. The DC District Court, to whom applicant appealed, agreed that human authorship is a bedrock requirement of copyright. That case has now been argued on appeal, and we will return to the applicant's contentions after a review of the Copyright Office's other registration decisions. In the second decision, in a letter canceling the registration of the individual images of an AI-generated graphic novel, the office concluded, quote, because the AI technology starts with randomly generated noise that evolves into a final image, there is no guarantee that a particular prompt will generate any particular visual output. By contrast, the Copyright Office registered the human-authored text and the applicant's selection and arrangement of the AI-generated images to tell Zarya's story. Similarly, in upholding the examiner's rejection of an artwork consisting of a mashup of the applicant's original photograph together with a copy of Van Gogh's The Starry Night, the review board focused on the lack of control on the part of the applicant in generating the combined image, concluding that the AI app's interpretation of applicant's photograph in the style of another painting is a function of how the model works and the images on which it was trained, not specific contributions or instructions received from the applicant. In another example, the review board affirmed the office's refusal to register Jason Allen's artwork Théâtre d'Opéra Spatial, in which Midjourney, a text-to-picture AI service, helped to generate. Allen stated that he input at least 624 revisions and text prompts and used Adobe Photoshop to modify his finally selected image. But these acts did not suffice to constitute human control, according to the review board, because the steps in that process were ultimately dependent on how the Midjourney system processed Mr. Allen's prompts. Allen has now appealed the Copyright Office's refusal to register to the Federal District Court for Colorado. The Copyright Office has not rejected the possibility that the output of an accumulation of creative prompts might cross the threshold into adequate human authorship, but it has made clear that the prompts must exert determinative control over the output. Simply reiterating prompts that trigger the same random processes will not suffice. After 624 prompts, Mr. Allen may have found an image that corresponded to his vision for the work, but simply selecting an image from a large number of alternatives does not make one the author of the chosen picture, nor of the other 623. In that respect, the applicant is no different from others who perceive aesthetic merit in objects they did not create, such as driftwood, which the Copyright Office will not register, or in found objects, such as bottle racks or urinals. By contrast, the office has registered a photorealist image produced using Stable Diffusion from a hand draw an underlying image created by the applicant. Applicants satisfied the examining division that their prompt sufficiently controlled the production of the image so that far from initiating a random process, inputting the same prompts would yield the same work. Applicant's letter to the examining division included an extensive chart detailing how the work visually expresses Castanova, same Castanova as Castanova's original mental conception for it. Castanova chose the work's subject and how to render that subject and exercised control over stable diffusion to ensure that the executed work realized their mental conception. The argument on appeal in Thaler versus Perlmutter departed from applicant's initial position that the image was wholly autonomously machine-generated. Thaler contended that human authorship lay in his creation of the machine and in the initial, very general prompting. In effect, while the Copyright Office has maintained that the putative author must be the determinative cause of the output, Thaler was conceding the need for human authorship, but urging a kind of but-for causation to identify sufficient human participation in the machine's output. In that construct, the human role would consist of creating and entering the prompts that result in an output. The prompts need not be so detailed as to constrain the machine to generate the same output every time, as assertedly was the case for Ro's Enigma. Were the prompts to meet that standard, ordinary copyright principles of proximate causation would apply. A but-for concept of authorship would do the work of deeming more outputs copyrightable, even if the inputs left considerable control to the machine. For example, were Saint-Exupéry's Little Prince to order the image generation program DALL-E to draw me a sheep, dessine-moi un mouton, that prompt would barely constrain the machine's choices for how to execute the command. By contrast, draw me a sheep with fluffy purple curls and a diabolical face furiously butting Little Prince on his asteroid while his Rose looks on approvingly, enjoying the scene, significantly limits the machine's choices, but nonetheless leaves substantial leeway for the machine to vary the theme. Two questions arise. First, does the statute accommodate a but-for concept of authorship that would result in finding the visual outputs of these prompts copyrightable works? Second, should it? An obvious objection points to the breadth of the outcome. Copyright protects expressions, not ideas. But a prompt such as draw me a sheep is an idea. With but-for authorship, the inputter of the prompt would become the author of every machine-generated implementation of the idea. One might try to avoid this conundrum by confining but-for authorship to prompts sufficiently elaborated to surpass the level of mere ideas to become literary works in their own right. In that instance, the owner of the copyright in the literary work consisting of the prompts, that description, would enjoy the exclusive right to exercise her prompt, effectively giving her monopoly over all visual outputs using the copyrighted prompt, despite the multiple different forms that execution may take. If we resist that extravagant outcome, it is because because we sense that the prompt's failure sufficiently to delimit the results of the machine's execution makes it akin to an idea. The Copyright Office's recently released second part of its study on copyright and artificial intelligence agrees. The Copyright Office stated prompts essentially function as instructions that convey unprotectable ideas. While highly detailed prompts could contain the user's desired expressive elements, at present they do not control how the AI system processes them in generating the output. Notably, the Copyright Office observed that the AI system may disobey the prompts by providing content the prompts did not ask for, or by omitting expressive elements the prompts did request, as you can see here. Conferring copyright on the myriad executions the machine autonomously generates gives the prompts a protection too thick for too thin a human authorial contribution. Other advocates of copyright for AI outputs have urged analogy to works made for hire. As we have seen, Congress has already bestowed the mantle of authorship status on non-human, non-creators, because juridical persons can be employers for hire, vested with the status of authors. If we have already surmounted the human authorship hump with works for hire, then making room for machine authorship should encounter no impediment, the argument goes. But this argument conflates the statutory status of authors for purposes of this title and the statutory specification that copyright subsists in original works of authorship, whether or not the work's statutory author is a human being. The work must be the product of human authorship, otherwise there is nothing in which copyright inheres. In other words, it does not follow that anyone or anything that Congress says is an author necessarily creates an original work of authorship. That phrase implements the constitutional subject matter of the writings of authors, which the Supreme Court has denominated forms in which the ideas in the mind of the author are given visible expression. Authorship gives expression. It creates, not merely acquires. An employer for hire, whether a juridical or a natural person, does not itself create. The statute attributes to it the results of the authorship, the copyright, of human employees. Properly understood, the work made for hire doctrine does not conflate authorship and first ownership. Without authorship, there is no copyright to own, and without human creators, there is no authorship. Oops. Nonetheless, one might ask, what's wrong with authorless copyright? Arguably, a machine-generated output can promote the progress of knowledge just as much as a human-produced work. Indeed, the relationship between knowledge promotion and copyright protection may be especially intertwined in the case of works such as Castanova's Zarya of the Dawn, that combine authorless AI-generated elements, the individual images, with copyrightable contributions, the text of the graphic novel, and the selection and arrangement of the images. The copyright law is clear, however, that the copyright in a compilation or a derivative work does not extend to elements that the author did not create. AstraZeneca would not be able to bootstrap the AI-created Zarya visual character to their compilation copyright. Any third party, therefore, would be free, as a matter of copyright law, to extract the character without the narrative and include her in new graphic novels or in audiovisual works or in merchandising properties, such as those imagined here, without a copyright to enforce against these potentially lucrative uses, right? You would all like a Zarya throw pillow? Prospective creators of hybrid AI inclusive works might lack adequate incentives to produce them. But the premise that encouragement to produce authorless outputs justifies vesting them with copyright supposes that copyright concerns only the promotion of learning and ignores the constitutional means, the writings of authors, by which knowledge is to progress. Two examples show why the progress of science fails to provide an adequate basis for vesting copyright in an authorless output. First, in Feist versus Rural Telephone, the Supreme Court asserted that original authorship was a constitutional requirement and declined to equate informational utility with originality. As the court observed regarding the White Pages telephone book there at issue, Rural expended sufficient effort to make the White Pages directory useful, but insufficient creativity to make it original. The court thus reaffirmed authorship as the essential criterion for copyright. Second, the well-established rule of independent generation bestows copyright on two apparently identical works, so long as one author did not copy the other. But if the second work is identical to its predecessor or nearly so, it will add nothing to the progress of knowledge. Justification for its copyright must lie elsewhere. Holmes's personality theory fits the bill. Copyright inheres in the expression of the author's unique individuality. That uniqueness may mean that no two works will be truly identical, as Judge Learned Hand observed in 1921. No photograph, however simple, can be unaffected by the personal influence of the author, and no two will be absolutely alike. But that divergence simply underscores why the essence of copyright is the expression of human individuality. I close with a coda inspired by David Nimmer's Columbia Law School Manges lecture of a few years ago. David presented a bonus quiz to identify the composer and performer of a recorded musical composition. Do you remember what it was?
I do.
Okay. My Extra is also a recorded musical composition of a partly AI-generated song about copyright law in the style of 70s pop group ABBA. The quiz question, with lyrics created by my human research assistant and with much prompted and cut and pasted machine-generated music, is the output as a whole an original work of authorship. So let's see if we can do this.
sing high with a machine.
Okay, so I hope we have a couple of minutes for question and answer and your views on whether or not that as a whole is a copyrightable work, including the selection and arrangement of the machine-generated music and sound recording. A spoiler, I guess, is next slide. Okay. All right, so my research assistant and I are trying to register this for copyright. And as a sort of in-joke, we filed the online registration application on the registrar's birthday. But we have not communicated with the registrar. We have communicated with the examiner, who wants us to claim copyright in the lyrics and disclaim copyright in the music and the sound recording on the ground that it's machine generated. So we replied, that is our reply, trying to explain why we think that the song as a whole is a copyrightable musical composition or recorded musical composition because of the way that the particular musical pieces were selected and arranged after their generation. We are waiting for a response from the examiner. If the examiner finds this convincing, or if we have to go up to the Copyright Review Board, and then we'll see. But I'm hoping that we can that we can prevail on our selection and arrangement theory, meaning that we can't claim copyright in any particular four measures, right? But in this context, I'm not sure that there's anybody has any interest in copying the original four measures. Well, we expect this to go to the Billboard top of the charts, and maybe even be nominated for a Grammy next year. But I think it illustrates the somewhat ambiguous position of works that are created with AI elements. Right? If we go back to Zarya, for example, if Castanova had, let's see if we can go backwards. Yeah, okay. So let's say that that image, the cover of the graphic novel, instead of just taking that output, Castanova had doctored it, right? So that there was more human input in her revisions to the AI-generated underlying work, right? At that point, she has not only a compilation copyright in the graphic novel as a whole, but would also have a derivative work copyright in Zarya, which then might enable her to prevent American Girl doll versions of Zarya, etc. Now, it is true that the copyright in the derivative work only extends to the new matter added by the author, so that the underlying work remains authorless and therefore not protected. But if she doesn't disclose the underlying work and the registration procedures do not require disclosing the underlying work, disclosing its existence, yes, but its actual content is not required to be disclosed, then de facto she controls the underlying work by virtue of having a derivative work copyright if nobody can get at the underlying work. Now, one might think that this is a little contestable, but I think that it presents a possible compromise for creators of works that incorporate machine-generated elements. Because one of the things I find a little troublesome with with Section 103, that you don't have, the derivative work doesn't affect the copyright in the underlying work, is the premise that the underlying work or the pre-existing elements pre-exist. But Zarya did not pre-exist. She came into being with the prompts by Castanova. So perhaps the equities lie somewhat more in favor of recognizing the copyright in the derivative work, even if nobody will get access to the underlying work unless she chooses to make it available. So, yes, in the back.
Hi, thanks so much for your talk. So I'm curious whether I take your view to be that the pure AI generated work does not get the protection of authors.
It doesn't have an author.
Correct, so it doesn't get it. But the audience often has a difficult time distinguishing between works they don't know. And presumably downstream users who would like to copy works not made by authors should be perfectly permitted to do so, but they will be uncertain about which is which. Do you have a suggestion about how the copyright scheme should handle this problem? What requirements of disclosure should be required so that downstream users know what they may safely copy?
In the EU, the AI Act has transparency obligations. It has upstream transparency obligations and downstream. So downstream, if you go back to there, you would have to have a little legend that says machine generated or something like that. Although again, I'm not sure whether you would have to do that if the image was initially produced by a machine, but then overlaid with original authorship. The AI Act doesn't get that specific, but there is a transparency obligation to disclose that the output is machine generated. And this is particularly important in the area of deep fakes, which is sort of copyright adjacent, but obviously a big issue. Upstream, the AI Act requires disclosure of the sources of the training data. This is something that American tech companies do not like, and there's the details of how that disclosure is to be worked out is still a work in progress, right? But there's, I think, the level of regulation in the EU is more author protective and more public protective than we currently have in the United States. Yeah.
Can I join Sean? I was thinking the same thing, but going the opposite direction. So I'm teaching copyright right now at UCLA, and tomorrow we're doing Kurtzeng versus Wiley, which is a case about importation into the United States of copies made abroad. And it's a Supreme Court case, and one thing the Supreme Court weighs heavily as they interpret the law is they say, look, we don't want to interpret the law in a way that will make it very hard for customers to understand what's going on. So they're positing that maybe we'll treat work that's made in France different from how we treat work made in Ohio. And they say, we could never do that. Because when you walk into a used bookstore, you won't know if it was made in Ohio or made in France. What a mess. And this is a theme all over copyright law. Google versus Garcia makes a comparable point. That's a case by notice and take down on YouTube. And the Ninth Circuit en banc weighs in heavily and says, wow, we want to limit the number of authors involved in a movie, because if not, it would be a mess for poor Netflix to clear the rights to put a movie up. We keep seeing the courts interpret copyright law with an eye toward the mess other interpretations might cause, which had me going the opposite way of Shauna, which makes me uncomfortable. I was worried the same thing, but thinking that maybe what that means is we should flip these readings of authorship and all these things that you rightly look back to, that now that AI is a new wrinkle in the ocean, all of a sudden we should look at those things and say, you know what, we could interpret it this way, but what a mess. We did have to require disclosures, as the two of you posited, which seems really hard to do. Everyone who has interest in not disclosing becomes a problem in that world, right? Whoever writes the next graphic novel like this, they don't want to say, I get no rights, here's my announcement of no rights. Is the problem you mentioned, that they actually might have some rights, it's really weird and confusing. That made me go the opposite way and think maybe if to all of us as readers, it looks like a graphic novel, and walks like a graphic novel, and treat it like a graphic novel, and stop worrying about whether a person was involved, so long as we know who has the rights. Because most of the time in copyright law, when we find about authorship, it's not are we going to create it, it's who we're going to give it to. And so I would think that this conversation takes us the opposite direction of humanistic and says, look, make it simple. You pick up a book, it's copyrighted, and our only question now is who has those rights. Hence work made for hire, joint work, all the rules we have to figure that out.
But if we're going to forget about authors, then one has to think about what rights there should be in these authorless outputs, right? Life plus 70 doesn't make any sense, right? And the scope of protection for an authorless output perhaps should not extend to the scope of derivative works that we have in copyright. I don't think it's enough to say that if it walks like a duck, it is a duck. I personally have some doubts about whether some kind of sui generis regime is needed or desirable for authorless outputs. But one thing is certain. If you take the author out of the equation, you have removed the second pillar of copyright justification, right? There's no natural rights. There's no authorial personality in a non-authored work, right? So that leaves you only with the incentive rationale. And if we're going to recognize some sort of exclusive right on the basis of incentives, then I think it is necessary to show that incentive is needed and what that incentive should look like, because otherwise we are going to overprotect. Neil?
Yeah, so there are a couple of Ninth Circuit cases, in Red Rooster versus Nike and Skidmore versus Led Zeppelin, where courts have held that the creative selection and arrangement of uncopyrightable elements, where there's a broad choice that could be made, but there's a synergistic combination of the disparate elements to make a creative work, is entitled to thick protection as an artistic work, right? Not just a compilation. In those cases, the elements were the facets of the photographer's craft, which were not protected by copyright, and the individual note combinations, which were not sufficiently creative for copyright protection. So could that reasoning also apply, or should that reasoning also apply to someone who takes sort of disparate elements, artificial intelligence created, combines them together in some original way, and creative way, and there should be entitled to protection as a creative work, not just a compilation?
Well, one could dissect a lot of creative works into effectively effectively compilations, right? The argument for the ABBA copyright song, right, is that it is a creative selection and arrangement of components that were machine generated. Right? And I think, and I hope that the Copyright Office will ultimately think that the work as a whole, right? So I guess one would have to disclaim discrete AI elements. I'm not sure how thoroughly one has to identify those discrete AI elements. New Copyright Office guidance is forthcoming, and maybe we'll have a better idea. Right? The explanation actually does identify the discrete AI elements. But I think that for almost any copyrighted work, you could, not just computer programs, you could dissect a play or a book, anything, into a series of tropes, right? Or stock characters, or you can take anything apart until it vanishes, right? But and if you're a defendant's lawyer, that's exactly what you want to do. But I think that we do recognize that very few works are created totally from scratch, right? That the creativity is in manipulating all those discrete elements that, standing alone, may not have been created, or at least weren't unanticipated, right? But it's how you put it all together. And I don't think that that should be different, whether you're talking about the A theme of a song, right? Or an AI component. Yeah.
Will this be our last question, and then I'll encourage everybody to connect at the reception, just connect to encourage conversation? Okay, excellent. That's great.
Thank you. My question was, I was wondering if you could explore a bit more the concept of authorship in the Copyright Office, because to me, when I think of, it seems to be a bit of an impoverished concept of authorship, to require, and I wrote it down, that you have to be able to control, predict, or visualize the outcome. Like, that doesn't seem to mesh with just how creativity typically works, and it seems to sort of limit authorship to the last step, right? I'm putting something on canvas. I understand that that's what we can protect, right? We protect the expression, so I'm not going to give you a copyright on the idea. But to me, that's different from what makes somebody an author. So I wonder if, right, an author may be somebody who is framing a problem, finding a problem, really refining a problem. That, to me, are also components of authorship, even though I can't copyright those components. So to me, right, there's a tension there between who is an author is, or what's the thing that you can copyright. And so if you could address that, to me that's a bit of a tension, right? Yeah, you can't copyright the idea, but coming up with the idea, coming up with the framing could be a component of authorship.
All right. The non-protection of ideas. The basis for that is not lack of creativity. You can have really creative ideas, but the copyright law considers that those ideas are essential building blocks, even if they're new ideas. That back to Learned Hand in the famous Amy's Irish Rose case, right? I assume that if you've taken copyright, you know this case. The plaintiff wrote a Broadway show, very, very successful Broadway show, about a Jewish family and an Irish family on the Lower East Side of New York who hate each other. Therefore, necessarily, the son of one and the daughter of the other fall in love. Right? So this sort of immigrant variation on Romeo and Juliet was novel and fabulously successful, so of course it was copied in a movie called The Coens and the Kellys, right? With the same premise, only they switched the son and the daughter. And so Ann Nichols sued, right? They copied me. And a learned hand concluded that they copied her idea and some of her in the stock characters, right? But not the detailed expression of that idea. So even if Ann Nichols was the first to come up with the ethnic variation, right, thereby anticipating Bernstein and Sondheim by 50 years, that doesn't matter. Judge Hand says that some things the author puts into the public domain, right? Now, but we don't have, there's no epistemological rule that tells us what's an idea, right? It is an instinct that judges have as to what people ought to be able to copy, right? And so if we translate that into the AI, right, it may be that the prompt, my variation on draw me a sheep, right, is unusual and perverse, right? But we don't want to bottle up other people working with that extended idea, right? So, and I don't think it makes a difference in whether we're talking about AI or traditional works. Right? There's an unstated and unquantifiable line between idea and expression. And I just wanted one other thing about the Copyright Office report, which I recommend. It's very, very well done. The Copyright Office is not saying by control, the Copyright Office is not saying that you can't incorporate random elements, right? Nobody is taking Jackson Pollock's copyright away, right? But when the Copyright Office talks, its concept of control, which I think is proximate causation, right? You're still incorporating randomness in a sort of tamed way, right? As opposed to an unleashed way, right? So the wildflowers, the court thought, I happen to disagree, but the court thought that the wildflowers were untamed natural forces rather than sort of incorporated natural forces. So the fact that there is some randomness in an AI output is not standing alone a reason for disqualifying it, but it's how much randomness. And that may be a bit of case by case, but that's copyright law. Idea expression is case by case. Fair use is case by case. I don't know that it has to be different in the appreciation of whether the more than de minimis AI elements are incorporated in such a way that as a whole it's a work of authorship, or whether you have only partial work of authorship, because at least as to the AI elements, there hasn't been a sufficiently close causal relationship between the author and the output.
Okay. Thank you.